And we don't think Ms. Ames did that, and we think that saying that what the United States says, that just eliminating the two most common reasons,
that
and then
could be all sorted out on remand, right? I mean, all we have before us is really what Justice Kagan was reading, I thought.
Well, our argument is that this court reviews judgments, and the judgment was correct. I think that everyone here agrees that everyone should be treated equally.
All right, so what is that treatment? What must a plaintiff do in your view?
So under Reeves, this court said, provide enough evidence that there's an inference of discrimination. This is also footnote 7 of Burdine, legally mandatory presumption of discrimination. And then the court said
do we not have the steps anymore within, that he was a member of a protected class, that he suffered an adverse employment action, that he was qualified and was replaced by someone else? Is that not how you conceive of this, as like the statement? You seem to be suggesting that evidence has to come in at this very first stage, and you have to really establish that you have been discriminated against, and I had not understood the first stage to be that onerous.
Well, we don't think it's onerous, but this is its summary judgment. This is after complete discovery, document production. Here, I think we had 6 depositions under oath. If you can't show any evidence that the employer was motivated by a protected characteristic when they took the adverse action, and certainly if you can't show an adverse action at all, that's not enough to create any burden of production for the employer. And that sample pattern of proof, the 4 elements that McDonald Douglas lays out, courts have adapted that under this court's guidance. So in Swearkiewicz versus Surima, this court said, before discovery has unearthed relevant facts and evidence, it may be difficult to define the precise formulation of the required prima facie case in a particular case. And so what those 4 elements happen to be, this court has directed lower courts to never treat them as an exclusive or...
I understand, but I guess, what's happening is that we have a burden shifting test that we have indicated on several occasions is sort of graduated in terms of how you get to the ultimate question. And I thought that what was necessary to shift the burden to the employer to come up with the reason or explain what was not supposed to be all the evidence that you have related to discrimination, that it was just enough that you say things or have enough evidence that establish an inference, that you could, more likely than not, and then the burden shifts and the employer really has to explain what's going on here.
Well, I agree with your characterization, Justice Jackson, and that's what this court said in Reeves, where the court made clear that if you have enough evidence at the prima facie stage that you could, looking alone at that, grant judgment for the plaintiff, then the employer has a burden.
So what was the failing? Oh, sorry, go ahead.
I just wanted to clarify what you were saying to Justice Kagan and Justice Kavanaugh. Do you agree that if the law in the Sixth Circuit is, as Judge Kethledge's opinion describes it, that it's wrong?
I think that if that were an accurate characterization, yes.
So this whole dispute then is really just about how we interpret what the Sixth Circuit said?
No, I don't think that's alone what's at issue, Justice Barrett. I think, the case that we cite, I think, is a better description. This per curiam opinion, we asked the department for oral argument, and my friends on the other side, too, asked for oral argument. The court just came out with this decision 2 months after the
So it might have been sloppy, maybe it wasn't stated well, but you agree that if it means what it says, what Justice Kagan read to you, or if Judge Kethledge's understanding was correct, you agree that that's wrong?
We agree. Ohio agrees that it's wrong to treat people differently.
So if we said someone like Ms. Ames, who is a member, it doesn't matter if she was gay or whether she was straight, she would have the exact same burden and be treated the exact same way under Title VII if she sued as someone who was gay and argued that they were discriminated against under Title VII. Same.
I think that she should have the same burden, and that the best reading of what the Sixth Circuit
did. No, I'm just asking you what you think of the statute. So that is what you think of the statute, and same for someone who brings race discrimination, someone who brings, a woman or a man who brings a sex discrimination suit on the basis of a discrimination against the basis of sex. All of those, you agree that the court should apply the exact same burden, treat them the exact same way?
We agree with that,
okay,
Justice
thank
Barrett.
You.
The only thing I would add is it can't simply be the tick through the mechanical rubric and then the employer has the burden to disprove liability under Title VII, that's inconsistent with the text of Title VII. And we think what this court said, I would point the court to page 3 of my friend's reply brief. They cite this per curiam, this unpublished decision from the Third Circuit that really re-articulates what the United States says at page 20 of their brief. And what they say at the top of page 20 is that the fourth element of the prima facie case should just be circumstances which give rise to an inference of discrimination. If that's the rubric that this court says it should apply in every case, then I think Ms. Ames hasn't made out a prima facie case.
So you're not worried about, you are not concerned, you're on the same page as your friends on the other side when it comes to the central question of how we should interpret Title VII. Your concern is that we'll say something more about what kind of evidence any plaintiff has to show, no matter what group they belong to.
Yes,
But if we didn't say that, you would be satisfied with an opinion that just said everyone's treated the same under Title VII.
Well, I think that courts could be misled by hearing that basically the prima facie case, as the National Employment Lawyers Association explicitly asks for, doesn't really play a factor in McDonald Douglas. McDonald Douglas is a judicial gloss on the statute that is trying to make it easier for plaintiffs, but it's not such that the burden is always and everywhere on the regulated party. The Title VII standard still requires the plaintiff to make out the burden of proof.
Sorry, why is it so hard on an employer to just say why they didn't hire someone?
Well,
I mean, you're making it sound as if by making out a prima facie case, it's unfair to the employer to say, you didn't hire them, explain why.
well, two responses.
They don't have to prove the why.
Yeah, two responses to that, Justice Sotomayor. Number one, the text of the statute allocates the burden not to disprove liability, but to prove liability. And so the prima facie case needs to be a complete case enough at that circumstantial stage before the employer has a burden under the text. And then secondly, doctrine. This court has said that that case needs to be enough to create a legally mandatory inference of discrimination.
But you seem to be putting this on its head. You seem to be saying that they have to be able to win the case on the prima facie evidence. That's what you're suggesting. Because what Judge Ketledge basically said, you have a situation here where she alleged she was a member of the majority group, she was 20-year employee, great reviews, and then all of a sudden she's not hired, and someone's hired who's gay, doesn't have her level of college experience, and didn't even want the job. It's something suspicious about that. It certainly can give rise to an inference of discrimination. Now, whether those facts are enough to make out that the employer's proffered reason is pretextual or pretextual in some way, the court hasn't gotten to that yet.
Well, so Justice Sotomayor, I think the really crucial fact here is every circuit, and we point this out in our bio, every circuit has said that if the employer isn't even aware of the protected trait, it's not possible to infer that they were motivated by that protected trait. And that doesn't come in at prong 2 of the McDonald-Douglas burden shifting. You don't have to disprove the negative. It's the burden on the plaintiff at a very minimum to say, they knew about your protected characteristic. And what the evidence here showed was that no one knew Ames or Frierson's sexual orientation. The petition appendix at 32A, the district court made a factual finding that has not been appealed here, that no one knew Ms. Ames' sexual orientation at the time of the relevant employment decisions. And Director Geese testified that he did not know Mr. Stojcevelek was gay, even though others may have suggested that in the record to other people, and that's at JA 46 and 48.
General, I guess my reaction to a lot of what you're saying is this. You say you agree with your friends on the question that we took this case to decide. The question presented is whether a majority group plaintiff has to show something more than a minority group plaintiff. Here, whether a straight person has to show more than a gay person. Everybody over here says no. You say no too. That was the question that we took the case to decide. And now you're asking us to opine on various other aspects of how the McDonnell-Douglas test works, what we should think of the first step as doing, then what we should think of the second and third steps as doing, that are, really not intertwined at all with that question. Whatever McDonnell-Douglas does, it does for majority group plaintiffs and minority group plaintiffs alike, is all that we have to say. Why shouldn't we approach the case in that way?
Well, I think there are two responses to that, Justice Kagan. First of all, while we all agree that everyone should be treated equally, we don't agree about what that prima facie step actually looks like.
Yes, I know, that's exactly what my point is. But that's orthogonal to the question we took. So, I mean, why would we use this case, which is about whether a majority group plaintiff has an extra burden, to opine on a range of things that have nothing to do with that question?
Well, so what the Sixth Circuit did here, this is my second reason, Justice Kagan, if the first one doesn't satisfy you, is exactly what we think every court should do. Ask for enough evidence to raise an inference of discrimination. And simply going through those four prongs, copy-pasting McDonald Douglas with subbing out racial minority for any particular protected group doesn't do that. It doesn't satisfy what this court said in Reeves and Burdine in footnote 6 and 7. And so our thought is the court should still affirm, because what the Sixth Circuit's judgment did here is what we ask every court to do at the first step of McDonald Douglas. Even if we agree that saying that an additional burden is a mischaracterization of what this court has said in the past.
Mr. Geiser, I guess maybe another way of coming at perhaps the same question is, what would be wrong with a judgment holding that everybody is treated equally at the first step of McDonald Douglas if it applies at summary judgment? We've never so held, but let's assume. And that you would then on remand be able to argue about what that fourth prong of the first prong of McDonald Douglas means for everybody. What's enough circumstances to give rise to an inference of discrimination? We wouldn't say anything that would prohibit you from making these arguments to that court in the first instance. And normally, of course, we are a court of review, not first views. Justice Ginsburg would like to remind us.
Well, Justice Ginsburg was very wise, Justice Gorsuch, and we don't want to make assumptions either way. I think that the court should still affirm. I'm defending the judgment on behalf of my client, but if the court is going to say anything about what that first prong happens to mean.
I'm positing a circumstance where we don't. Affiant saith not anything about what that first prong means, other than to say it applies the same to everybody.
Well, we agree that the court should say that at the very, very minimum.
We're in radical agreement today on that, it seems to me. The counsel before us seem to be in total agreement. And then, if your argument is, as applied to everybody, she fails on the fourth prong of the first prong of McDonald Douglas, perhaps a court should take a look at that before we do. What would be wrong with that?
Well, I think there's something in between those two levels of abstraction, Justice Gorsuch. We agree on that first level, and we think that the court can avoid that sort of third level down. But the second level here—
Boy, I'm lost. We have four prongs and three prongs and four levels. Just what's wrong with the opinion I outlined to you?
Well, I think a lot of courts are going to get the misimpression that that first prong of the prima facie case, that McDonald Douglas step one, if it applies equally to everyone and the court saith nothing further about that, that it just means the burden is on the employer to produce evidence.
Why would that be? We would say, I mean, you know, you, as the government points out, you point out, everybody points out, you've got to show you're a member of a protected class, 1. 2, who's qualified for the relevant position. 3, was subject to an adverse employment action. And 4, and this seems to be where the dispute is, was taken under circumstances which give rise to an unlawful discrimination. And you say that's not met because the relevant decision makers didn't know the plaintiff's sexual orientation. Interesting argument. Not presented here. Let a lower court pass on it first. Why wouldn't that be a wise course for this court to follow?
I think it would be wise if the court adopted the 4 prongs read just as you read them, Justice Gorsuch. And if the court doesn't want to say anything more about that, we still think the court can affirm, but if the court is going to make sure to say what is at the top of page 20, I think that would be good guidance for this court to give.
Well, I thought this is not what I think we should do, but I'm just going to throw it out there, which is if we talk about McDonald Douglas, I thought once the employer stated a reason, the whole thing kind of drops out. And then, as Justice Gorsuch says, you're just figuring out, was it based on the stated reason or was it based on a prohibited characteristic?
Well, I think there are two issues with that. Number one, if you have a case like this one where the employer has good evidence that they didn't even know the relevant protected characteristic, the employer shouldn't have to say, if I want to make that argument, I also have to forego providing a legitimate reason if I want to be able to win on that first fundamental threshold. So under the Brady opinion in the DC Circuit, I think there's a really good argument that McDonald Douglas no longer applies. This court has already said it in Aiken at trial, and it doesn't apply because this court said it in Surema at motion to dismiss. What does it do in summary judgment? I still think there needs to be room for the employer to proffer a good reason and use that as an alternative grounds for, and the plaintiff didn't even meet their prima facie case. In other words, the employer shouldn't be forced to choose one of those two possible
we
litigations.
fired the person because of X, and we didn't even know they were, whatever the characteristic is.
Well, I think,
I mean, I don't know if calling it prima facie, I'm far afield, but, as you're aware, I don't think that's pretty very useful to how to figure out these cases once the employer has stated a reason. So I'll leave it there, though.
I think the court should allow employers to be able to make that alternative argument. They didn't make a prima facie case, and we have a good reason, and either is a grounds on which.
Well, I think I agree with that, but they're both arguments for why it wasn't discriminatory. I think that the decision to fire the person was not based on their sexual orientation or their race or what have you. It was based on something else.
Well, I think they both do go to the ultimate question, Justice Kavanaugh. I do think, though, that one is a very negative shield sort of argument and the other is an affirmative sword sort of argument, and the prima facie case is there to capture, was there enough evidence to show at sort of freezing time and place with no answer at all from the employer that Title VII elements could be met, that there could be an inference of discrimination at the first step. And I don't think the court should retreat from any of those statements that it's made from Burdine to Fernco to Reeves.
Okay,
Thank you, counsel. Any further? No? Thank you. Rebuttal, Mr. Wang?
Thank you, Mr. Chief Justice. I'll be very brief. I just want to conclude, I think, with several members of the court have talked about this theme, and it's actually something that my co-counsel, Mr. Gilbert, and I talked about when entering the court this morning, which is, I think, what this case is all about. And those are the 4 words on the side of this building: equal justice under law. Equal justice under law. Now, I know that sometimes we don't fulfill that promise. I understand that. But at the heart of this case, at bottom, all Ms. Ames is asking for is equal justice under law. Not more justice, but certainly not less. And certainly not less because of the color of her skin or because of her sex or because of her religion. We're simply asking for equal justice under law because I think that's what Title VII says, and I think that's consistent with what this court has held in numerous cases, and it's consistent with Congress's intent in passing a civil rights law to protect the civil rights of all Americans.
Thank you, counsel.
Thank you.
The case is submitted.
The Honorable Court is now adjourned until Monday next at 10 o'clock.
What's Fogarty up to? Who? Fogarty. He's back to the office. Getting his nails. Blood test first, and his eyes, so he has a red splotch. He's also got ring, white spring. Your vitreous back wall, your features is something in your back wall. Detached. Most of the movement is kind of roof. I now see this big heavy. You got it. Yeah. Oh, it's one of those trucks. It's a car. I've seen them before. Oh, here they come. Oh, these people? No, I mean the protests. Protests in China. There's stories about discrimination. Yeah, and get shots.
Oh, okay. I love the fact that you don't have to wear a jacket. Is that not a great?
First nice day in a long time.
Yeah, I know. I'll give you a count.
Okay, thank you.
You realize I've said all this stuff so you don't have to work out the drug.
Say what?
I said, you realize you've got to set up so you don't have to work out the drug.
Happy birthday.
That's why I'm here doing that. I just thought I'd make a guest appearance, okay? Mic check 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. You might, I don't know if you want to move. I don't know. You go where you want. 1, 2, 3, 4, 5. Mic check test 1, 2, 3, 4, 5. We're good? All right.
Yeah.
Sure. We're going to be out of here.
We're all taking their happy snaps. Greg, when you get your last, you've done easier up there. So I'm back this way. These are the plaintiffs. People who want their rights. Not the state. The state is a violation. These guys? Yeah, they argue. They're people that argue for right.
Have a good one, Abby. Yeah. You guys want us?
Please. Yes.
Can you? I gotta get the bag out of the way. I think so.
Whatever you need. You know, so it is warmed up here.
I forgot to bring my makeup kit, though, so I can't.
Yeah.
We're cameramen, so we're just doing softball. We don't have producers. Yeah.
How'd it go in court today?
Well, it went very well. I think the justices were pretty straightforward, and I think that the presentation was great on our side. I want to thank Professor Wang for assisting us in that regard. We feel that the justices were pretty clear that actually both sides agreed that the lower court was wrong, the elements were not followed properly, and we expect that the court will issue a fair decision.
Can you tell us in a nutshell kind of like what the conflict is? I gather it's kind of like whether a group of people have a distinguishing characteristic can or cannot be discriminated against, and you know, what's the cusp of this case? What makes this interesting?
I think the cusp of this case. I think the cusp of this case is whether all individuals under Title VII should be subject to the same legal standards and same terms, rather than having some individuals, just because of whether they're in some majority group or minority group, however you want to define it, are subject to different and higher terms. So I think that's the crux of this case.
That everyone should be treated equally, irrespective of their group status, whether you're gay or whether you're black, whether you're white, everyone should be treated the same. That's the bottom line of what we're trying to get across today.
From the questions that both sides of the allegedly liberal justices and allegedly conservative justices, but that might be a myth. Yeah. What did you glean from their questions? Are they seeing your argument?
I think we'll wait until they issue a decision to see.
But you couldn't feel from arguments today?
I think both sides did a really great job, and I think that we're hopeful for, as Ed said, a fair decision and a decision in our client's favor.
How is your client feeling about everything today?
I haven't talked to her since the argument, but right before the argument, she was very positive, and we felt it went very well. And I think she is very grateful that the justices heard her out.
Can you tell us what happened to her?
Well, she was denied a promotion, and she was also demoted. These positions went to gay individuals who did not interview for the job, did not apply for the job, and in one case did not even want the job. However, she was denied those jobs and demoted to a secretarial position and lost a significant amount of funds as a result of that demotion. And it was all because, in our opinion, because she was straight, and they wanted to give the positions to gay individuals.
Okay. We're good?
All right.
Thank you.
Excuse me, sir, do you mind saying and spelling your first and last name? I apologize.
Yeah, my name is Edward L. Gilbert, E-D-W-A-R-D, Gilbert, G-I-L-B-E-R-T, and I'm counsel for Ms. Ames from Akron, Ohio. Thank you.
And would you mind saying what your name is?
Yeah. Xiao Wang. I'm a professor at the University of Virginia School of Law.
Spell that, please.
Thought I was done with you guys. X-I-A-O, first name, last name, Wang, W-A-N-G. I'll give you guys my card just in case you need it. Thanks, guys. I appreciate it. Thanks for all the hard work.
Can you imagine you were down there talking to Larry Sabato?
Oh, yeah, I love Larry. Yeah, I've known him since I went to undergrad at UVA, so we don't see the What a nice guy. I mean, he's just genuine. I've always...
You've been into his
house?
Yeah.
No, it's actually I was coming down the front there.
No, it's like a living story.
Every election.
All the better.
Oh, thank you guys for doing this. Yeah, thanks, guys.
Thank you.
All right.
Two down. Good work.
Is there anybody else we're looking at? I don't think so.
I don't know where she is.
I don't think she does. I think she's all fuckered out. Some of the people have misconstrued her words. And she totally disappointed. Yeah. So that didn't work very well for her. Okay, thank you. She have such a good reputation.
Good to see you.
Just getting to be sort of
I know.
another month, another
Love
case.
too.
It doesn't matter whether it's stated. Because I think it is pretty good filing. Oh, really? Okay. I think it's filing.
Oh, my God. You're awesome.
I just try to do my best. Yeah.
You did.
Yeah, we got a good shot.
Doesn't matter how you cover it.
I know, he broke his glass.
No, I told him to break a leg. I wanted to break a leg.
I was coming down the outside. They don't think they're fine.
Oh, when you were saying that, you were saying you had to be, watch that you didn't miss a step, but you did miss a step. Well, you can't fight a battle sometimes without a few casualties and a little blood. Good to see you again. Well, now can you get a picture of all of us? I mean, we still have the decision to come, but you've been through pretty much the whole process. I'm still in town. I'm one of the instructors at the UVA. Good to meet you. It's 1 in a million, maybe more than 1 in a million, getting your case to the Supreme Court. It's kind of as we were talking, it's a little bit of a mixed blessing.
Yeah, it is. I mean, it's a long haul, but.
All right, so we're going to take some pictures. You want the court in the background? Yeah, sure.
Can I everybody for 60 seconds? I got one dude who really wants to meet you. He worked on the case last year.
Beautiful day. Nicer than the last time we were out here. Very, very short. Very short. I think everyone has one question. Everybody else back down.
Yeah. All of this, I'm going to get that.
Yeah. We agree on that narrow question. That's right. Yeah. But that's fine. Okay. Yeah, you said this. I haven't spoken in 20 years. Today. Yeah, he said it was only a sentence or two, which is good, which is what he wanted. He did not want to do a separate. They said it was. I know he had a really good to really get it. I love listening to your dad. Yeah, you did.
Yep, don't forget about that.
You gotta wear this lucky suit.
Oh yeah, you're wearing that suit. Yeah. I'm getting matching suits. Yeah, I'm going with you.
He's happy.
But when you do, yeah, of course we talk about that on business. That's fine.
Everybody who goes to law school knows this. Fiduciary duty is the obligation, the most fine, moving basically outside of my duty it was.
So sad.
Okay, we got a UVA set a very professional photographer.
Oh, yeah.
Yes, of course. That was trying to. Students are in the gift shop. So they're gonna help get them. Yes. Yes.
Oh, okay.
Okay. I'm gonna wait till we have that reply. All right. I'm gonna get quite a few. Okay. So I'm gonna get some from below. I'm gonna get some from above. All right. We're getting Get one on yours, of course. And then I would like to get a few more with this other camera. Well, okay. Let me get a wide angle on here. And I'll make sure to get one on the cell phone as well. I know it's very sunny.
We got lunch planned. You got They can head over. Let me go talk to them. And then there's wine and beers. Maybe some champagne. If you want something strong, you just want Johnny Walker, that's fine. Not really, I'm tired of it. Who are you with?
I'm with Next Star.
Don't take questions. She can say what she wants to say. Okay. All right. All right. Okay. Then. Okay. This gives Ms. Ames not going to take any questions, but she'll just make a comment on how she felt that the situation went today and what she thinks about her case. So you can step up here, okay? All right. This is Marlean Ames, the plaintiff.
Hello. I feel confident on how it went today. The justices saw clearly what was the issue and didn't want to go outside of that realm, which I applaud them for. I feel like maybe in the future at this point, everyone will have a fair bite at the apple on discrimination because, again, discrimination is discrimination and each individual case is different. So hopefully that is the way of the future, and I feel good that what has transpired today.
All we're looking for is equal review of any case that comes before the court. We're not asking for any more or any less, just an equal opportunity. Thank you very much.
Thank you.
still recording?
I'm not right now.
No, him. What are you taking a picture of?
Yeah, throw him in here walking away.
Yeah. You know where that guy was going with that question, right, Kurt?
Yeah, you're really gonna ID freedom of press with him in front of the Supreme Court?
Says a lot about this. A good check? I want to see a camera? Just drop it. Any interest? Let me check that's yellow.
Yeah. You know, equal opportunity.
You have to send it there.
Huh?
The guy that argued the arguing counsel is inside the waiting room. Right. It'll be those guys. We did our job.
You did it.
You got charged for producer. $3.75 a day per day.
We got a professional photographer. You want to?
Oh my gosh, really all.
Yeah, professional photographer.
Again, this was $3.75. Yeah, or I get a free soda. Just look.
Yeah.
Yes. It's not, look, if we don't get it, it's not the end of the world. Yeah? It's just a nice to have.
Right. That stage is coming through now.
No, it's okay. It's all right. I mean, it's argument time is over for this for this year. I think for this term. Let's hope not. I got some notes I shot. We get something in October, November, but I'm not worried about any of that right now. Yeah. So can you join us for lunch, Bob, or no?
No, I've got to rush back.
Yeah.
I guess you heard President Trump declared war on my law firm.
I saw it.
This we're representing Jack Smith, who was the special prosecutor of the pro-government. So he issued this ridiculous order
singling you out, you guys.
revoking the security clearances of our white-collar lawyers who are very, one of them was the head of the criminal division of the Justice Department. It's totally just retribution. The laws and I didn't do anything wrong, but even if we had,
So you have your plate full.
But I've got it. It's so below this, I'm going to file a circuit court appeal as not the case before the days. Well, and I do some kind of the outcomes. Plus that law switch. Yes, I told my wife Well, we need to have you here. We want to have the whole class here. We had a little disaster in Copeland. Not paying attention to our heating system. And we knew it wasn't working back in one part of the house yesterday. The bathroom in the living room, and the radiators froze, and then they burst, and then we just had but most of the house is operational. The guest room bathroom is not operational.
Are we talking about coming by Greenwood at some point? Okay, great.
We'll see if we actually maybe now when there's crossing.
That'd be great.
I was saying the main guest room is out of commission. We have disaster. We have backup.
Oh no.
We've got the nicest bedrooms like
yeah, great.
Well, we'll think of it as
Yeah. It'll be very nice.
That's the mental picture.
Okay. That sounds good. Well, safe travels to Florida. Bob's going to be at the Boca Raton Club on Friday.
someone's got to do it.
Yeah, I gotta ask you how I can get an affiliated status or something because I can go on these firm retreats. Yeah, you know, yeah. So now I'm great, but I'm real great time. You can use the students and help them for that.
Well, I'm going to get out an email before the end of the day. It's trying to do a whole copy. Join in if you feel up to it. We'll push it ahead with another one.
Okay, sounds good. We'll pop it.
Congratulations. Congratulations. 2 up, 2 down.
Yeah.
It's amazing.
Yeah, I think we've got a good shot
I do too.
of it. All right. She got back up there. Dave? What I do? We know about it. We should get air tags.
Okay, now we're just taking the finances. If you all want to go,
You guys go in? I mean, it might actually be something. I think it's 6 and 6.
yeah, if you all want to go for it.
Unless you're doing it just for yourself, or you're doing it just for
flip side also, in addition to these, maybe this is maybe. Yeah.
I'm Maddie Beer Temple next summer. Nice to meet you.
Your partners, underwriters, Trump cards.
Oh, everywhere. And what was your name?
Greg.
Oh, nice to meet you.
Maddie, I'm Jay.
Hi, Jay. Nice to meet you.
Trouble for CCS.
Mark? Good to meet you.
All right, which guys now?
To the left of the tall guy.
Right. So it's the guy with the light blue tie, yeah?
Huh?
Is that blue tie?
Yeah, the guy with the who's
Let's see. Say how it is.
I generally like the White House, but
Our spot.
oh, really?
Second from the
Yeah. Trump's.
No. He's walked away, he's walked away. go pitching where it's more than a brother. I'd go the pitching.
And so devastating. And number one, I want to see people stop. And they're not from here, they're from primarily two other countries. And then, by the way, let's talk about the Middle East. We got to solve that problem too. And that's come a long way. We're doing very well in that also. A lot of things are happening on that.